Hello again. Today's scenario focuses on a large health and wellness center that integrates IV therapies and deploys a naturopathic doctor, ND, supervising nurses. I'm Michael H. Cohen. I'm still founding attorney of Cohen Healthcare Law Group. We help healthcare industry clients like you navigate healthcare and FDA legal issues so you can launch or grow and scale your healthcare business. Let's start with the statutory definition of ND so we can understand what an ND can and can't do. Differs by state. In California, for example, Business and Professions Codes 3613 little c in the parentheses defines naturopathic medicine as a distinct and comprehensive system of primary health care practiced by a naturopathic doctor for the diagnosis, treatment, or prevention of human health conditions, injuries, and diseases. NDs as primary care providers trained and licensed to diagnose and treat conditions and diseases are allowed to perform a wide variety of services, including perform physical exams, order your lab tests, as well as diagnostic imaging studies, dispense, order, prescribe, and furnish or perform a variety of procedures, including dietary supplements and non-prescription drugs as defined under federal law, as long as consistent with routes of administration designed by law. As long as services are within the ND scope of practice, quote, a naturopathic doctor may utilize routes of administration that include oral, nasal, auricular, ocular, rectal, vaginal, transdermal, intradermal, subcutaneous, intravenous, and intramuscular. There you go, TMI. The statute also sets forth requirements for the ND to qualify to administer IV therapy and the requirements for documentation of the patient record. The important glitch here is to notice that the ND Act does not authorize a naturopathic doctor to practice conventional medicine. More specifically, Business and Professions Code sections 3642 sets forth certain activities prohibited to the naturopathic doctor, like prescribing, dispensing, or administering a controlled substance, except as authorized, and there's supervision by an MD or DO for ordering drugs, reliance on standardized procedures or protocols, and there must be availability of the supervising physician by telephone. There are a few exceptions, like use of an EpiPen, prescription of hormones, and use of botanicals. Now, by comparison, in contrast, pardon the pun, a registered nurse may dispense drugs or a device only upon the order of a licensed physician and surgeon, or certified nurse midwife, nurse practitioner, or physician assistant. The ND Act in California does not authorize naturopathic doctors to write orders for or supervise registered nurses, physicians, or medical assistants. That might surprise you. Aiding and abetting unlicensed persons in the practice of naturopathic medicine in California and assisting in the violation or conspiring to assist in violating the ND Act are defined as unprofessional conduct. The same with violating the Medical Practice Act. The bottom line is that even if the MD runs the overall center, the ND has to strictly follow certain rules. Otherwise, the MD could be a risk for aiding and abetting unlicensed conventional medical practice. Nurses, as mentioned, they've got to follow standardized procedures and their legal rules that spell out at least 10 different components that standardized procedures have to contain. Well, thanks again for watching. Please contact us with questions. We've helped so many healthcare industry clients just like you build their dream, and we look forward to working with you on your journey to success.